Welcome. Thank you, Terry, for having us, and welcome. We're glad you're here today. So I'm Karen Fisher, and Barbara Ransom is also on the line, and we're going to be discussing the Endrew F. Supreme Court case. But before we get into the details of the court case, I want to introduce a little bit more about myself and let you know that I am also an autism mom, and for many years, I think we still are actually constituents at the CARD, even though I took a job up here in Georgia, and I'm now an assistant professor of special education at Georgia Southern University. And I became interested in the law when I started teaching graduate classes of special education law, and learned more and more. And I was teaching that class when this lawsuit, when the hearings were held in Washington, D.C. at the Supreme Court. And my students and I, debated it and we discussed it within that. And I happened to be at a conference that that the presenters were talking about the law. And one of those presenters was Barbara Ransom. And that's where I met her. So I'm going to go ahead and let her tell a little bit about herself. Go ahead,
Good
Barbara.
morning. Good morning. As you can see, I'm a civil rights attorney practicing in disability rights advocacy, and I'm also an adjunct professor at Lesley University, where I designed and teach a class involving autism spectrum disorder and the criminal justice system. Um, the class is basically project oriented, and there have been a lot of really great projects and discussions about accommodating persons with disabilities who may find themselves in the criminal justice system. I'm also the team leader of a work group at TASH, that is a national organization dealing with disabilities advocacy, and the work group is Endrew F. Um, and that's how Karen and I work together in spreading the word about this very important piece of litigation that the Supreme Court has put on our plates. So let's get to it, Karen.
All right, so our agenda for this short webinar, we have an introduction where we're going to talk about who, what, and why of the Endrew F. case, and how did the parents challenge the school district. We're going to talk about the results and FAPE and how this case redefined what FAPE means to your students and to your children. We're going to give you some resources, and then at the end, like Terry mentioned, we're going to have some question and answer. Go ahead, Barbara.
So, who is Andrew F? That's what parents usually want to know because, especially as a parent of a child with a disability, you hear all these names and you don't know. So, we decided to give a very brief background of this fifth grader with autism. He had multiple behaviors that limited his ability to access the general education curriculum. I put that in quotation marks because it's directly from the legal decision. And you'll see quotation marks throughout the presentation, and that means the language comes directly from the decision of the court. In the IEP process, Andrew's parents complained that his academic and functional progress had stalled. And many of you will hear the word or may have heard the word plateaued, meaning that there's nothing further that the district can do for your child. So the parents removed him from the public school system and enrolled him in a private school setting.
And within that private school setting, which was ABA based, he made significant progress. So the parents filed a due process hearing to request, tuition reimbursement from the school. These are things that you may have heard of. And in Colorado, at that time, the IEPs only had to confer an educational benefit that is merely more than de minimis. So that means that it only needed to be just slightly above the minimum. So basically, plateauing or just doing very little is acceptable according to the courts at that time. So parents appealed the decisions that were made up to the Supreme Court.
And I'll elaborate just a little bit on that. When the Supreme Court gets an appeal, it doesn't have to take the case. But this case was important to take because there was what we call a split in the circuits. Some parts of the country said more than de minimis, and some parts said nearly de minimis, and some parts of the country said it can be less than de minimis. And that language is what propelled that litigation forward in the courts. SCOTUS, the Supreme Court of the United States, agreed with the parents. The court found that merely more than de minimis was actually a slap in the face of the IDEA, and they sent the case back to the district court with clear directions. And those clear directions included the fact that the IEP must provide more than merely de minimis. In a state like Pennsylvania, that standard in the Third Circuit, so Pennsylvania, Delaware, and New Jersey always had a standard that said more than de minimis. And as a matter of fact, that word nearly seemed to incense Justice Roberts, and that word has been removed from the lexicon of IEPs, hopefully for forever. And the IEP must be reasonably calculated to enable the child to make progress. Making progress was important to the court. The degree of progress must be appropriate in light of the child's circumstances. And that was like a stumbling block for us as advocates for these children. Karen?
Oh, we both clicked on it there. It's both of us clicking. So what happened? Well, as you know, the Supreme Court decided in favor of the parents. It was sent back down to the district. I mean, to the state courts, right? Right, Barbara?
The Court of Appeals first.
Yeah,
The,
the Court of Appeals, and
and
then
then to the district.
to the district, and from there the district settled. So there is a confidentiality agreement, but rumor or articles have suggested that the district paid the parents $1.3 million to settle the case so that they can provide Endrew with FAPE in a private school setting. And so they're going to pay, for all the back, the attorney's fees and the tuition for Endrew to continue his private school placement. So as a result of this Supreme Court case, FAPE, or Free Appropriate Public Education, has been redefined.
So, what is a free, appropriate public education?
The Free Appropriate Public Education has to do with the IEP. So the decisions that are made by the IEP teams, they stem from an understanding of what it means to provide a student with disability FAPE. And all begins with assessment, right? So before your child can be eligible for an IEP, they must be assessed. The Supreme Court stated in their decision that it must be appropriate and thorough. And not only that, the school psychology organizations right now are really trying to understand the Supreme Court decision, because not only did the Supreme Court state that the IEPs need to be appropriate and thorough, but they must measure the child's growth, so the child's potential for growth. And so what the Supreme Court said was, we need to figure out how your child can do in the future, not just where they are now. And as you all know, with a child with an IEP, assessments, they are assessing where the child is now. Where the child can read, write, do math, but where can they go in the future? Do you have anything to add to that, Barbara?
Yes, the National Association of School Psychologists published an article, as a matter of fact, um, writing exactly what Karen said. That this is this is the crux of the matter. How do we determine what a child's potential for growth is? Um, And that article I can provide it to card so that you guys can have access to it also, because that becomes important in the IEP team process. You start with something that has been assessed, and this is where your child is now, but who can tell where your child can go in the future? And the important thing about the assessment process is that parents have a right, if they disagree with the school's assessment and determination of that potential for growth, parents have a right to say, I want an IEE, an independent educational assessment.
So, just to go back a little bit here, though, and I think most of you probably already know this. So after the assessment is highlighted because it's the most important, because it drives the rest of the IEP, including your goals, services on the IEP, and then lastly, the very last thing that should be decided in an IEP process is the placement. Your goals and services should not depend on the placement, but it's the other way around. Where is the best place your child can be served to meet the goals that the student needs? So go ahead, Barbara. I think this is your slide.
Uh, so, notice of action. Every written notice of action refused given to a parent must focus on the standard of faith. Why is the parent requesting the particular action, and why did the team decide to say no to the service?
And if I may add on to that, what this means is every time that an IEP team refuses something that you request in writing, so hopefully you all know you should always request in writing, they must give a reason back. And this is specifically stated in the Supreme Court case. The district must provide in writing, and they must justify why the team said no. So why did they decide to decline your requests for services for your child? So, and that's a little bit more strict than what's been said in the past, if I understand it correctly.
Yes, because generally what has been said in the past is we considered what the parents wanted and we decided that this is best. That's that was generally all that the district did. We considered the parents' request for reading Wilson reading or whatever. We considered it, but we decided that this would be best without any data or anything. It was just a blanket. Okay, nod the head. Yeah, okay, okay, okay. No.
Yeah, they have to justify their reasons for saying no. So, and it can't be because of money. All right. So the next slide, the next slide, we're talking a little bit more about Endrew F. And again, this is a direct quote from the case where the school must offer an IEP that is reasonably calculated to enable a child to make progress that is appropriate in light of the child's circumstances. So when a child is fully integrated into a regular classroom, providing faith that meets the unique needs of a child with a disability typically means providing a level instruction that is reasonably calculated to permit advancement through the general curriculum. So what does that mean? That means that the Supreme Court wants our students, no matter how severe the disability, to have access to the general curriculum no matter where they're placed, whether they're in self-contained or in an inclusion class. They need to have access to the general curriculum and they need to advance, just like a student without a disability. Whoop. Go ahead, Barbara.
If progressing smoothly through the general curriculum is not reasonable for a child, its IEP need not aim for grade level advancement, but must be appropriately ambitious in light of the child's circumstances. What does that mean, appropriately ambitious? That's one of the measurements that should be determined When the goals are set, the school district should know and understand the child's abilities through the assessment process. So when the IEP team sets the goals, those goals must be reasonable. I think that setting goals is just a matter of routine. You pick a goal and you just say 20%. He must perform 20% of that goal by such and such by the first quarter, another 20% by the second quarter, another 20. Nobody's paying attention to the progress reports on the child. And in most cases, not even the parents are paying attention to what the districts are giving them as quote unquote progress reports. This is where a parent can show that they are active and they are involved by looking at those progress reports, seeing how those progress reports actually are consistent with the child's ability based on the assessment process. Karen?
That's right. And this is where the educators in Endrew F, what the Supreme Court didn't like is because they had said that, well, Endrew had plateaued, that he was never going to make any more progress than he was at because of his autism. And that the law said that de minimis is fine. And that was their whole defense was the law says we don't have to have ambitious goals. He can plateau and work on the same goals every year and until he masters them. The Supreme Court said no, that is not appropriate. So how did the parents challenge the district? So now there is no more of this de minimis or just barely making progress. The child's potential for growth must be assessed during assessments. High expectations are the norm, and modified curriculum is something that must be done. And what we mean by that is modified general curriculum. And Barbara and I had a conversation about this because I believe that this means that you're going to see a lot more of the general curriculum, even in your self-contained classrooms for children with more severe disabilities, rather than a separate curriculum like, say, Edmark or Unique Learning, because those are separate. They're not the same curriculum that all the other students are learning. And so we're going to see a lot more, we believe, of the general curriculum that's modified to meet the needs of every learner, no matter how severe the disability.
Now, the interesting thing about modified curriculum is that modifications to a curriculum are basically a term of art that's used both in the IDEA and in the ADA and in Section 504 of the Rehabilitation Act. That is an accommodation for a person with a disability throughout that person's life and across those statutes. Modifications in work, modifications in housing, modifications are consistent with what we think of as the right of a person with a disability. The failure to modify has always been identified as discrimination on the basis of disability. It's not like discrimination against someone because she's female or because of religion and you tell somebody to stop doing something. It's discrimination by failing to make those modifications, make those accommodations. Okay. Why did the judge rule in favor of the parents? Well, behaviors. The judge found that the student's behaviors were not properly addressed, and his behaviors were what was impacting his ability to make progress on his goals. Now, as parents and advocates for students with autism, we know that intellectually many people with autism are able to work on the general education curriculum. However, there are because of this neurological disabilities, there are impediments that make it difficult for the child with a disability to actually with autism or any neurological disability to actually demonstrate exactly what it is that they can do. Um, and therefore, many children with autism have not been afforded due care, as this court has seen under when it ruled on Endrew F.
Right. And what this means to you is, and I don't know about many of you that are on this call, but I had my son with autism had behaviors, and so he had some of the same behaviors that Andrew had. Andrew was throwing desks and throwing chairs, and he was eloping. He was doing whatever he could to get out of doing work. And I imagine that sounds familiar. It certainly sounds familiar to me. And what the school used to do with my son was call me and tell him to come pick him up because they knew not to suspend him. I think that because of this lawsuit, because of this Supreme Court case, you're going to see less and less of that because now they have to address behaviors. So, what are some tools for advocacy to help now that you know more about this lawsuit? First of all, make sure that the evaluations are complete and comprehensive. Start looking for that growth that the Supreme Court is asking for. Make sure that their accommodations and modifications are made to the general education curriculum. You have every right to ask for these things. And progress reports, that's something that Barbara mentioned a slide or two ago. What she's talking about is the IEP progress report. Now, when I used to teach special ed, we had to send out IEP progress reports with every progress report or report card that every student in the school received, whether they had a disability or not. So we would send home a report on how they were doing on their goals and objectives, and stapled it to the report card or the progress report, that the parent had to sign and turn in. Well, with the Paperwork Reduction Act, IDEA actually stated that now the special ed teachers only have to send it home with report cards and no longer progress reports as well. If you're not receiving progress reports on your child's IEP, request it. They are supposed to receive it. My son right now is in ninth grade in a public school, and he doesn't receive them. I have to ask every single time because report cards are now online, but his progress reports on his IEP goals is not. And I don't think that's being provided to other parents because they don't know to ask. But the IDEA says you need to get that report and then monitor it. Make sure they're making progress on their goals. Because if they're not, you need to ask for a meeting and ask for, a revision of the goals.
Here are some resources, two resources. Um, One is for TASH, the organization that I spoke about that we're part of. Karen and I are both on the Endrew F work group, in the Endrew F work group. And we've been putting together, it's a work in progress. We've been putting together some resources for parents. There are some audio and visuals there for you um, to look at in order to help you understand a bit more. We're developing a toolkit so that it gives parents a guide for when they're in an IEP team meeting, when they're monitoring their child's progress, when they're looking at the homework and the assignments that their child is giving. I had a case recently, and we sat down and we went through all of the paperwork that that child had for a year. Every strip of paper, every homework assignment, every classroom activity. We went through it all, and we developed a protocol to measure whether or not the child's activities as related to his IEP were consistent with the goals and objectives in the IEP. And we found 90% of what the child was exposed to during that school year had no relationship at all to the child's IEP goals. It was very disturbing. We settled that lawsuit. It was in the Eastern District of California. The understood.org has a two, I think it's 2-page sheet that you can look at and get some additional instructions for um, for advocating for your child through Endrew F.
Yeah.
And I think
It's
now
actually
we're
four.
ready
Yeah,
for
it's
it.
actually 4 pages, but
Yeah. So they're all handy tools. Every tool is good. So we have time for some questions and answers.
Okay, so
Questions and hopefully
yes, thank you both. And I'm going to activate people's microphones who might want to ask a question, but type in the chat pod in the meantime if